We're going to look at the contempt of court and the media. And this is something that affects us quite a lot. And it's not something that is going to go away. So it is better we raise the awareness and understand what it means, and also get some guidance about how to avoid such a pitfall. And this is something that cuts across all countries or continents. And so Uganda has had their own share of issues about contempt and the media. Kenya has the same thing. We are going through the same thing. As a matter of fact, just I think 2 days ago, somebody was cited for contempt at the Supreme Court of Ghana. So we're just going to go through that briefly. And the whole idea, the whole tension between contempt of court and the media stems from the fact that both institutions are very powerful institutions in society. They all have their own recognitions in various international conventions and domestic legislations like constitutions. So if you look at the Constitution of Kenya, if you look at the Constitution of Uganda, if you look at the Constitution of Ghana, the media, the judiciary all have a mention there. And so the media is supposed to inform and educate and entertain us. And the judiciary is also supposed to actually bring us together. That is where the administration of justice is dispensed. And therefore, when there is this tension between the media and the judiciary, which leads to contempt, then it's something that we need to all worry about. What is contempt of court? Basically, when you hear contempt of court, what you just forget about all those long talk about what contempt is. Basically, what it means is that when you, through your own acts, either through writing or word, when you do or say something that has the tendency to make the administration of justice look bad in the eyes of people, then basically you are on your verge of committing contempt of court. That long talk that you see on that slide, that is basically what it means. When you do something, calculated or not calculated, that has the tendency to make the administration of justice look bad in the eyes of right-thinking members of society, then you're committed contempt. And there are various some common reasons for being cited for contempt. Failure to obey an order of the court. If you fail, the court gives you an order, and then you fail to obey that order, then you can be cited for contempt. If you are a media personnel, the court says do not publish details of victims of sexual assault, and you go ahead and you publish it, you can be cited for contempt. Showing disrespect to a judge or a magistrate in a courtroom, including violent behavior, disrupting court proceedings or activities, or publishing matters which may prejudice the fair or trial of a case. And that is where we, the media, that is where we are actually found wanting all the time. And there are two divisions, in other words, classifications of contempt of court. We have the civil, and then of course there is the criminal. The civil basically is when you willingly disobey any judgment or direction of the court. And then the criminal has to do with any publication or matter that has the tendency to scandalize. But when you look at the way contempt has developed, now that line between criminal contempt and civil contempt has been blurred. So it has become meaningless now. So it's almost the same thing. So you don't have to really worry about whether maybe this is civil contempt, so I might not go to jail. You could commit civil contempt and you can still be jailed for that. Ghana and Uganda, we don't have any statutory provision that deals with contempt of court. And that is one of the big challenges that I'm sure probably during question and answer we will talk about that. Because when you don't have a statutory provision that deals with contempt, what that means is that the court itself, the judges themselves, are going to be exercising a common law authority. And that means that there is no legislation that provides regulations, guidelines about how these things are done. In other words, this gives impetus to the law being in the bosom of judges. And when you look at the way any case is started, there would have to be a complainant, there would have to be an investigator, there would have to be a prosecutor, and there would have to be a judge. Now, when you don't have a statutory provision that deals with contempt, what happens is that the courts, they become the complainants, they become the investigators, they become the prosecutors, and they become the judges as well. And that is why it is a tragedy. And that is why Kenya had actually gone a step further, and they have actually enacted a Contempt of Court Act, which a lot of other countries have done. And that is actually the way to go, because that way then you regulate the authority that the courts have in that way. And as I said earlier on, the area we as media personnel, the area we have to be very, very careful about is the sub judice rule. That is when a case is pending in court and then you are seen to be commenting in a way that is actually going to interfere with the course of justice, or you are publishing or producing some material that has the tendency to actually suggest in one way or the other that you know what the case is going to be. What are some of the defenses of contempt of court? The only defense is the defense, one of the main defense is the truth. If what you said is the truth, then it's an absolute defense. But if it is not, then you are in trouble. But even if it's not the truth, but you said it and it's a fair comment based on some factual nexus, then you can use that as a defense as well. And then, of course, accurate reporting of judicial proceedings that is made in good faith. That can also be something that you can use as a defense. The question the one would ask is, does that mean that judges are immune from criticisms? Far from that, no. Judges cannot be immune from criticism. What they are saying, what the law of contempt is saying is that it's not saying don't criticize judges, because judges are human beings. They can be corrupted, they can engage in an unacceptable conduct, but do not impugn any motive to the decisions they make or to the actions they are taking. So what the law of contempt is doing is it's just trying to protect the administration of justice as a whole. And as in a famous case called Amber versus Attorney General, one of the very interesting judges said that justice is not a clustered virtue. She must be allowed to suffer the scrutiny and respectful, even though outspoken comments on ordinary men. In other words, we as media personnel should not be, but in criticizing them, do not impugn any motive to the way they went about things. So do not say, oh, the judge did A, B, C, D because he's a member of this political party. He did this because he was giving money. That is what it's not acceptable. And Lord Denning, in conclusion, said that, let me say at once that we will never use this jurisdiction to uphold our own dignity. That must rest on surer foundation, nor will we use it to suppress those who speak against us. We do not fear criticism, nor do we resent it, for there is something more important at stake, which is what? Freedom of speech. So then the judges themselves recognize that freedom of speech is a fundamental right that everybody has. So they have to be ready to be criticized, but the criticisms has to be measured. Do not criticize in a way that has the tendency to destroy the administration of justice, because all of us, the arms of government, executive, legislature, the judiciary, and the fourth estate, which is the media, all of us, when we have an issue, we all go before the same judiciary for adjudication. And therefore, we do not want to do anything that would bring it disrepute. That is basically what the law of contempt, in a just nutshell, is all about. We can criticize, but
Uncle, did
criticize within the I would be ready to take some questions if there is any. Thank you so much. Over to you, moderator.
Woo! Thank you so much, Tanko, for that explosive presentation. And I think that you clarified a lot of issues with media and contempt of court. Colleagues, if you have any questions, please share, raise your hand, and also if you cannot speak up, you can as well use the chat box. As we get the questions coming, I really want to appreciate all of you for staying put. We are getting close to the end of the agenda, but for now, let me get Winnie and then Julius. And since we are out of time, I'll really limit only those two questions. Thank you, John. Winnie? Please unmute yourself.
Thank you, Abbas.
Okay.
Yes, I've unmuted you. Can you hear me?
Yes.
Yes, I can hear you.
Yes, my name is Winnie Odwod from Radio Namlolo in Kenya.
Go ahead.
Hello, Tanko.
Yes, Winnie. Go ahead, Winnie.
I'm not sure if I missed this, but maybe you can clarify for me from the other side in Ghana. I don't know what you do or normally do when a person is convicted of contempt of court, because in Kenya, We have an act which whereby when a person is convicted of contempt of court, you are either fined around 200,000 Kenya shillings. That's about $2,000 if I'm not wrong, or maybe 6 months imprisonment, or maybe both can apply. So I don't know, because you mentioned that you don't have an act that guides. So I don't know if I missed it. So maybe you can clarify from.
Yes, you're right. So yes, because we don't have an act that defines this, everything is now left with the judges to decide. And what the judges have done, we have precedents where people have gone to jail. There have been instances where the people have gone to jail and they have fined the person as well. Or there are instances where they will just give you a fine. Or there are instances where they will ask you to purge yourself of the contempt. What that means is that they are just asking you to go and use the same platform you used to scandalize the court, to apologize and tell the whole world that what you did was unacceptable. So there are those options as well. And it all boils down to what the judge at any particular point in time thinks he would use. But what would go into that would be whether what you said and who said it, it's an aggravating circumstance or not. But in Kenya, you are right, they have a fine where the statute has specifically indicated that there is a fine and then there is imprisonment of 6 months, a maximum of 6 months imprisonment. But that is the beauty of having an act. When you have an act, it regulates the judge. The judge cannot then go out of what the act stipulates. So I think kudos to Kenya. You've said the way. Hopefully Ghana, we would also be taking a cue from them.
Thank you very much.